Hello, everyone. My name is Bernie Wolfsdorf. Welcome today. We are doing another EB-5 Reform and Integrity Act update. I'm going to try and keep talking for a minute or so while we get you to all log in. Joining me today is my partner, Joey Barnett. Or as I say, the smart one. Every time we need something intelligent said, I will be turning to Joey. For amusement, you can listen to me. I will be the humorous side of EB-5 for today, keep you engaged. I will remind you that we do have a chat column, chat function. Feel free to put your questions in. We're not going to do live questions today, but we will be answering any questions you have. I do have one request, and that is that you please keep your questions short, one sentence. We don't need the whole story. It's got to be brief. While I'm talking, Joey will probably answer some of your questions. And looks like we've got fairly decent number of people coming on. We'll give them another minute or so. In today's presentation, we're going to update you on what happened during the USCIS listening session. Gosh, it was quite a, let's use the word interesting listening session. Everybody was jumping up and down with frustration. I took a slightly different spin on that listening session because we had Urjadu, the new USCIS chief, personally appeared, and I can vouch for the fact that this is a good person leading. And we also have a new director of the IPO, somebody very experienced from within, Alyssa Emmel, and she, I believe, is going to do a good job. I'm actually optimistic. At the end of the day, Congress passed a new law, and the government is attempting to implement it. That's a fairly challenging process. Well, looks like we have a critical mass here. So I'm going to get started. Again, for those of you just joining us, my name is Bernie Wolfsdorf. My claim to fame is I'm a past president of the American Immigration Lawyers. I serve on the AILA EB-5 committee together with my partner, Joe Barnett. And thank you again, everybody, for joining us. Bernie Wolfsdorf, managing partner. My email address is my name, bernard@wolfsdorf.com, together with my partner, Joe Barnett, or as they called me on the USCIS webinar, Nod Wolfsdorf. I kind of figured it might be me, so people are now calling me Nod.
Nard Dog.
Nod Dog. As long as they don't call me Nerd Dog, then I'm kind of okay. But there we go, a little bit of silly humor to get us through. jbarnett@wolfsdorf.com is where you get intelligent answers. For something off the cuff, you can go to bernard@wolfsdorf.com. Just a little reminder, this is not legal advice. This is for information purposes only. For legal advice or legal opinions, you do have to have a consultation with one of the WR lawyers. So there we go. Know how to reach us. All right, some of this stuff is repetitive, but we're going to include a lot of the new stuff as well. So the new law was, and I'm going to fly through this stuff. The new law was signed on March 15. Oh, little typo there, 2022. It's not 2,000 years ago. It was just a month ago or so. The new regional center program starts May 14, but a lot of the provisions are already effective. So you'll see I deal with this later. If you've got a pending adjustment, scratch that. If you've got a pending 526 and you are not chargeable to China or a backlog country, you can file your adjustment now. So if you haven't done it, at the end of this webinar, reach out and contact your lawyer, or if you are the lawyer, contact your client and get the adjustment filed. Of course, there are the complicating issues such as underlying status. The old program has been repealed. This has made everybody tremendously nervous because those of you who think you own a regional center or run a regional center, you do not. I'm not sure what it is that you run, but your regional center just got canceled. They're making a lot of noise about canceled culture. Now we have canceled regional centers. They all got canceled. This is going to get challenged in court, but the bottom line is there is a new number 956, the ominous 956 application for RC designation. Nobody has seen the 956. We will see the 956 before May 14, 2022, and we hope to be filing some 956s. This is the new form for regional center designation. The question is, how many are going to be filed and how quickly will they be adjudicated? Because nothing can be done without a 956. This is what got the audience really upset during the listening session. But if you stop and think about it, the regional center program has been repealed. We have a new program, so we need a new designation. Could we have done it with attestations? No point talking about it unless the plaintiffs who are suing succeed. So if you've got an RC, you must file your form 956 in order to maintain, or I'm going to even say resurrect, your regional center. So here's the big bad news. They will not accept regional center 526 filings until the 956 is approved. How long will that take? Perennial Pollyanna Bernie is saying it could be done in 2 to 3 months. My prediction is there probably won't be more than about 100 of these files. I think they can plow through them and get them done in a month or two, and the program will start moving again. Joe, my partner, I'm not going to give him a chance to speak, is far more pessimistic, and he thinks I'm on cloud 9. So I'm not going to ask him to speak. I've just let him sit there and smirk because he thinks it's going to take much longer.
Well, I'll just say that they have in the legislation, they say they're supposed to do studies to do quick processing. And one of the goals in there is to say these regional center designations with their quick processing is, they say 180 days in the legislation.
I know, but the program can't move without it. I'm telling clients, look, it's going to take a few months to get redesignated. What is a few months? We don't know what a few months means. But come on, Joe, how long does it usually take to do a source of funds report? All the clients say that, oh, I can do this in a week or two, but in reality, the source of funds reports end up taking 2 or 3 months. And if it's coming out of China, it takes quite a while now. In terms of the new source of funds, document the requirements, 7 years of tax returns, difficulties with exchanging funds. I mean, this is going to take a few months. So yeah, there's a hiccup.
And I'll also say that previously when regional centers filed I-924s, they usually did it with an exemplar, with an actual project included. That's not allowed at this time. So there is less work for USCIS to do with a 956 than a 924. So that should also speed up the process.
What exactly is in this 956? They're going to do a background check, obviously, make sure that you're not a bad guy. We get that, part of the integrity. I mean, it's not like, I don't think these things are going to be very meaty, and I don't think I think they can adjudicate these things relatively quickly. I think they heard from the community and they realized they need to be done. Let's wait and see. Bottom line is you can't file your 526 I still feel comfortable signing a case at this point because there's so much to do, preparing, getting the source of funds report ready, getting everything ready to file. So yeah, it may take a few months, and that's a little problematic for some of the people in the US on F1 OPTs expiring, et cetera, et cetera. But hey, Joe, the new thing is we even got 245K in the program, which means technically your client can go without status for up to 180 days. Your client can be illegal. I don't like using the word because that means criminal, but out of status for 179 days, working without permission for 179 days. And bingo, if you file your combined processing 526-485 on the 179th day, your client is legal and approvable. So you know what? I'm liking a lot of this law. All right.
And sorry to interrupt.
No,
and
please.
if there is, real timing issues, direct EB-5 is still available at this time, and you can do a concurrent processing direct case today.
I assume there's some good direct EB-5 projects. I've seen possibly one or two. I'm very concerned still about direct. Firstly, there's no more pool direct. That's got to go with regional center. But if there's a single individual regional direct program, yes, create that full-time, 10 full-time jobs. I have actually some big news on that, Joe, that I'm going to announce later with regard to the China Direct program. I've got some breaking news on that. That's kind of a little scary, but I'm going to keep that teaser for the end to make sure you all listen the whole way, because I believe I have some valuable information on the Chinese direct waiting line. So, Joe, what is this thing about you need the template receipt number to file the 526? So what you're telling me is a 956 alone being approved is still not enough. They also have to submit a project template on another form yet to be published, and we're going to need the receipt, not the approval, for that template. So presumably, as the way I understand this, is this way USCIS is not going to re-adjudicate the project 100 times if there's 100 investors, right? So there's one template, it gets linked with the receipt number. The only thing they're looking at is source of funds, etc. So as long as your project gets approved, pretty much everybody in that project should be approved unless they have source of funds reports. Is that correct, Joe?
Yep, absolutely. And a regional center can also seek approval of an amendment to, so, if there is some sort of change later on, rather than all investors having to file, this project update, the regional center can file an amendment to that approved project application, which would also speed up processing times.
So Joe, I know it's like difficult to change the tire when the car's moving, okay? And this thing is moving not even in the beginning of a fiscal year, but halfway through a program. So it's kind of difficult. You do have to stop. You do have to pull over to the side of the road. I understand it's not, Formula One where they do these change the tire in 15 seconds or less. This is going to be a little bit slow with regard to changing the tires. But Joe, isn't this a better system, quite frankly, that you've got new designation, you've got compliance, you've got the project template, it's directly linked to your filing. At the end of the day, this is what we've been asking for, isn't it? In terms of
yeah, to an extent for new cases, yes. I think if regional centers or pre-existing regional centers could continue their current designation, then yeah, I think people would be very much okay with this current setup. It's this new 956 that seems to be causing a lot of hoopla.
Yeah, no, I got that. But, the bottom line is, let's be optimistic. I think this is a different group running USCIS. I think these people are genuine in their attempt. Let's wait and see if, in fact, they are successful. So while everybody else is angry and upset, I am strangely optimistic that the new EB-5 Regional Center program is going to work. Joe, here's a complete question from the left, the right. Where is it coming from? So Joe, interest rates are rising. getting mortgage rates are rising. The last time this program exploded was because interest rates were rising. This is another alternative way to raise capital. So I think we're going to see a lot of big players diving into this. If MERS financing is running at 12, 18%, and they can do EB-5 for 3 or 4%, I think we're going to see a rebirth of EB-5, right?
Yeah, absolutely. I think a lot of folks in the US use EB-5 to lower their cost of capital. And as long as it's structured correctly, you could do bridge financing. You can use EB-5 to replace that short-term bridge financing. And it really can lower the cost of putting a project together. Absolutely.
And I love Suzanne. She's the, I've got to give her a plug because her blog is so good. Lucid Writing. We really love it, but I love her number. She mentioned 27 billion in this program. 27 billion. I can't even imagine how many zeros that is. Is that 9 zeros or 12 zeros? It's too many zeros, but it's a lot of money. And that's how much we've got in EB-5. So, you know, I think probably in a few years, maybe there'll be 50 billion in this program. You know, there's going to be a demand, and now, you know, it's pretty much $1 million, right? We'll go into that in some depth.
I have a question here that's sort of about the 9526, about assumed average all-in costs for an I-956.
I don't think we can answer that right now. If you want my opinion, I mean, the cost of preparing one, or
yeah, I mean, you're gonna have to put together the policies and procedures that is required under the legislation. There's going to be a filing fee that you're going to have to pay.
I think a hefty one, by the way, if you want my opinion.
Yeah, I think so.
I think we're going to see some like $50,000 filing fee or something stupid. They had 18,000 on the last one. That was the highest filing fee, but I think they're going to increase it because they need money for the integrity fund, right?
Well, there's also additional fees that they're going to have to pay every year for that as well, on top of the filing fee. Yeah.
It's 20,000 if you're over 10
20.
cases.
20.
Is 20.
Yeah.
20,000 if you, otherwise it's 10,000 minimum, which, yeah. Anyway, folks, that's the story in regard to the new program, the status of the regional center program. There's only one person who's moderately happy with it. It's me. Everybody else in the industry is not. So I'm regarded as the outlier on this one, because I'm strangely optimistic that USCIS can get its act together. Remember, Mallorca's processed nearly 1 million DACA cases in a few months. 1 million DACA cases. Don't tell me that Mallorca's and Urgedu can't do a good job in fixing the broken immigration system, and I'm weirdly optimistic they're going to get it done. All right, let's move on. Status of current EB-5 cases. So the program was basically grandfathered. So all those pending cases continue to be adjudicated under the law that was applicable at the time of filing, whatever that was. And USCIS has resumed processing of Regional Center 526s. Allegedly, on the visa availability, we got an approval yesterday, Joe. It wasn't a Chinese applicant, though, right? I think it was a Turkish applicant. But whatever it is, trust me, it's good to get 526 approvals again. It's been a little bit of a while, and they're starting to come in again. No RFE on that one, which was great. So, but we're a little bit worried that they're not processing Chinese cases other than those that are were filed probably in 2016. So using eligibility requirements prior to this new law, which RIA, I don't know how, what do we pronounce that? RIA, do we have an acronym for it? RIA.
RIA.
Old RIA. I can see you in my rear view mirror. Old regional centers, no longer designated. I've hopped on that. Everybody's upset. You own a regional center? Well, what exactly do you own right now? Oh, I just bought a regional center the other day, Joe. I paid $200,000 for it. What's it worth today?
Zero.
Zero. Wow. I'm not very happy. I bought a regional center. It turned out to be worthless. Actually, I didn't buy a regional center, but probably some other people did. So, okay. Here's the other good news. USCIS processes the adjustments. NVC is processing documents, background checks, and Department of State is scheduling interviews abroad. I got so many interviews scheduled for China, Guangzhou. Joe, I didn't see too many for Vietnam. What's going on? Why are they slow there? China's,
we got a couple, but not nearly as many as Guangzhou. That's the big one.
Yeah. They should increase the number in Vietnam, but we got a bunch of Chinese appointments. So that was exciting. I mean, the train's moving, things are moving nicely, and people are grandfathered if they filed before September 2026, so they don't have to worry about this program expiring again. All right. New EB-5 requirements. I think everybody knows this by now. The point kind of that's interesting is the delta is only 250. So, I mean, getting into a rural high unemployment area, you know, presumably these are priorities. I don't know if they're going to get processed faster, but some people might want to just choose a regular project because do you really want to, I mean, I get it if you're a ski resort in a real rural area, but it's potentially more risky to be in one of these areas, presumably. So maybe some people would rather just put in the $1 million and not bother. Have you got any feedback on that yet, Joe, from prospective clients? I mean, if you're spending, you know, 800,000, do you really want to be in a rural area? Or, you know, why not just do the $1 million and be safe?
It's something I've given as a thought for people to consider, but no, I haven't gotten it either way. But I think it's a huge point. The minimum investment amount difference for TEA and non-TEA is half than it was before. It went from 500,000, now it's only 250,000. So that absolutely could have an impact on people's investment decisions for sure.
And of course, this goes up every 5 years. It's automatic based on inflation. And the new, I don't know if we could still call it TEA determination, the new high unemployment. I want to just keep referring to it as high unemployment rather than TEA.
So in the legislation, you know, they have the new types of reserved or set aside visas, whether it's high unemployment, rural area, or an infrastructure project. But the legislation still does refer to targeted employment areas. And the targeted employment area is, you know, it relates to the high unemployment as well as the rural area. It's where they want, it's pretty much where they want the investment funds to be going. And they're trying to provide incentives to investors to get the funds there.
The bottom line is it's still 150% of the national unemployment rate. The bottom line, it's very similar to the previous TEA, right?
Correct.
Okay.
Well, based on what was in the 2019 regs when the donut, so they have to be adjacent to the actual parcel in which the project is located. You can't sort of gerrymander it. Yeah.
I like that description of the donut. It's got to touch the side of that. You can't make it into an Italian boot or the Carbo boot and go down and across, etc., etc. So yeah, but that determination is no longer made by the state. It's now made by the feds, and it's valid for 2 years, presumably renewable. Yeah, that could be a problem if after 2 years it's no longer a TEA, right? I mean, but as long as it was a TEA at the time of filing, you're safe, correct?
Right. Or time of investment, yeah.
Or the time of investment or the time of filing the 526. I guess it's pretty much the same. I think it was at the time of filing, but I may be wrong. We'll have to look at that. Not important. Let's move over to the big stuff. All of this.
Sorry, before we get there, Suzanne asked a good question. For what priority dates are you getting Guangzhou appointments? We're not necessarily getting appointments so much as we're getting notices saying that NVC has all of the documents
No,
that
we are getting appointments, Joe.
Well,
You're not seeing them. I'm seeing them. I'm getting
Oh.
specific dates. The problem is I'm not checking to see what the dates are, but
Oh.
they are presumably current. We can answer Suzanne separately on that,
Okay,
but you don't get copied on those. I get copied on all of them.
got it.
I got a flood of them. So it's
Well, I'm
kind of
just saying we are getting those documentary completed emails from NVC for folks who filed in 2016 for China.
Yeah, we're getting a ton of those, but
Yeah.
obviously they're not scheduling for 2016.
Right.
Charlie has given me an indication we might see 2016, but remember, 2015 was the end of the program, and we had such a surge of filings right up until December 20, I think. So until we get past that little hump, we will see 2016 move much faster. I mean, it's still kind of ridiculous, 6 years of waiting. But at the end of the day, I think once we get past that December 2015 hump or bump, we're going to start seeing a whole lot more appointments getting scheduled. Okay, let's move on to this new and exciting topic of reserved visas. This was Grassley's baby. He wanted reserved visas, 20% going to rural. With I've got some interesting numbers on the reserve visas. I'm going to do a bit of a deep dive on this today. 20% for rural, it means almost 4,000, 3,900 for this fiscal year. It is a terrible shame that most of these are going to go to waste, because the problem is if we don't get 956s and we can't file, how do we get the reserve visas? And for many Chinese nationals looking or hoping to get green cards relatively soon, this is the open path. But they're going to have to be a little bit patient, because I don't think too many of these are going to get issued in the current fiscal year before September 30th. We're already in May. So maybe we'll get to file some one steps in September. Chinese 526/485 in rural, high unemployment or infrastructure projects. If they're in the US, OPTs expiring, H-1B, L1, F1, we may be able to file one steps for you. I call them one steps. Everybody's calling them concurrent. Either which way is good. That's the 526 and the 485 together. I think that's going to be a really big deal. The whole big shift of waiting for consulates to schedule abroad after the mess at NVC. What is it, Joe? There's 4 or 5 million cases stuck at NVC. The number was just astronomical. A lot of them are backlogged, of course, so they're not current. But I mean, talk about a nightmare at NVC. But they are starting to get their act together and move those cases. So, Joe, question. I don't think we have the answer, but I'm going to ask it anyway. So I filed under the old law, and my project's rural. There was under 20,000 population, and I'm outside of an MSA. These facts are black and white. I invested 500,000 during one of the lower period eras. Why can't I upgrade to a reserved visa? Or are these only for people who file after an enactment? What's your take on that one, Joe? I know you can't answer it, but I think it needs to be asked.
Yeah, it's a great question. I think one of the big unknowns that we have, it seems that these reserve set-asides are only for folks who file new cases after enactment. So a pre-existing investor, someone who filed in a rural project back in 2017, for example, would not unnecessarily be able to qualify for one of these set-aside visas. And when we spoke with Charlie Oppenheim, who used to work for the Department of State, I know that was one of the things that he said was still an unknown, and there needed to be some sort of coordination between DHS and the Department of State to determine, what numbers are there so that if they were going to use those, what the demand would be and how that would impact the final action dates.
Well, in regard to rural, I don't think there are that many Chinese rural filings. It's only going to be
Probably
the
not.
Chinese that are going to
Yeah.
want to move up, unless India and Vietnam get backlogged again. They're going to want to move up too. But there are lots of high unemployment TEA. So basically, if you could transfer the old ones, wouldn't that gobble up the entire quota, right? I mean, there would be no set aside because there's so many already in the pipeline that would chew up the entire quota. So if they are going to allow people to transfer their old priority date, that effectively kills the new reserve visas because they're not going to get any priority, correct? On the
Correct.
TEA thing.
For the high unemployment, correct.
For the high unemployment / TEA definition. For the rural, it might still be good. So if they allow, Charlie called it petition porting. I don't know if that's the correct word, whether people can port their old petitions to the new category. And the answer is we don't know. We're going to find out soon. If I was a Chinese investor with a 2016 priority date, I would definitely want to go after one of these, possibly in the context of an adjustment, possibly I'd even fight it in court. And Joey, I know you filed almost 50 cases in the last 2 years in federal district court. Is this the kind of case you might consider taking?
Sure. I think
you've got to study it.
Yeah, we have to study it, but I mean, I think really a lot of times when new legislation comes out, you kind of have to test the limits. Sort of waiting for the government to make a determination generally is what you need to do to have a final agency action to challenge. So, there could be some issues there, but if we're able to get some sort of indication that someone wouldn't be considered part of these reserve visas, then that might be sufficient to say, hey, this is incorrect based on the plain language of the Reform and Integrity Act.
Joe, interestingly, USCIS actually welcomes some of this litigation because, it's not on them to try and find the solution. If the courts are able to read the statute and provide guidance on what the correct answer is, then it lifts the burden off USCIS. You can't argue with the courts, right? So unfortunately, there will be litigation in this arena, and some of that litigation will be helpful.
Yeah, I mean, just even today, they announced the big changes for the automatic extensions for EADs. That includes folks who have adjustment EADs. Certainly, I'm not going to say I did anything about that, but we have a lot of lawsuits that challenging those delays, people who lost their jobs because of the processing times. And I think maybe that impacted part of their decision to extend it out for another 360 days.
Exactly. That litigation will often lead to justice, not directly, but indirectly, because USCIS resolves the underlying problem. The problem of EAD processing taking 6, 8, 10, 12, 15 months when people can't work or continue to work. And now we have automatic extension, which we did have in a lot of other categories. It's not a complete solution, by the way, Joe, but it's better than what we had. So, I'm happy for that. So, Joe, what I've heard is China is very unhappy with this RIA. Those people who've invested, the mood in China is bad. And a lot of people are already making the conclusion before Charlie has that the line is going to get 32% longer. I think that these investors are probably quite smart, and I think this is quite sad. For those people who have been waiting for years and years, the possibility that their line just got 32% longer because of these reserved visas is looking real. It's very upsetting. And I don't know what to say other than, how many times can you kick people? Kick them once, kick them twice, kick them a third time. This is a tragedy. if in fact those people with 2016-17 priority dates have to wait an extra third. Joe, I want to talk about something. If one of those people decides to pull out their investment, maybe the loan's matured, they get their money back on that and then refile on a rural set aside, I'm talking about a backlog Chinese, that could make sense, right? I mean, get your 500 back, put in 800 and refile, so it costs you another 300,000, but there's no waiting line. If you're in the US on an F1, that's a viable strategy, right?
Absolutely, and in particular for a Chinese national who filed maybe 2017, 2018. Yeah, that
get your money back, refile as a rural and capture one of the reserve, provided you're in the US, and then you can one step a 526, 485. Good thinking, Joe. Actually, that was my idea. Good thinking, Bernie. But be that as it may, yeah. The truth is, folks, somebody's already doing that, and I'm just repeating the idea. It's not my original idea, but it kind of makes sense, you know, that you could actually take one step back and move two steps forward with this ridiculous waiting line. So I want to talk about this. So as you can see, we have 5 categories. This is the May Visa Bulletin. This got everybody excited. Everything is current for every nationality, India. But the problem is doing regional center direct is you can't. So current for 5th preference unreserved, I5, R5 doesn't really mean anything right now. You can't really file regional center cases. So yeah, good for the pipeline cases. The rural set-aside stuff, current, but you can't really get it because there's no regional center program. So this is kind of hot air. If you look at all these different categories, you say to yourself, well, wow, everything's current. The only problem is we can't get them.
Yeah, only the top row, or I guess the second row, 5th unreserved C5, T5. It's the only thing that is really in business right now.
And that's a direct project. And then there's always this question is, you know, what's my exit strategy on the direct project? The regional centers usually have a good exit strategy to get your money back. The direct, less so. I'm not saying they don't all have good ways to get your money back, but it's not the same. Now, Joe, I got some bad news here. One of the things everybody was excited about is the fact that China was current for the C5, T5. I'm not revealing my source, and please don't sue me if I'm wrong. This is not legal advice. But my understanding is that next month in June, and you're going to see this probably around May 15, May 20, the China C5, T5 category will go back to November 2015, or maybe December. So they are going to recombine these two categories, C5, T5, I5, R. So if you're one of those people that's from China who's trying to file a direct, do not wait until June. You are going to miss the boat.
Well, you don't even have to reveal your source, Bernie, because they made a note of that in the May Visa Bulletin.
Oh, no, in the May Visa Bulletin, they said they may do it.
Okay, so this is okay, got it.
I'm going one step further.
Got it.
But thank you. Yeah, my big secret is not a big secret because it's in the May Visa Bulletin. But for those people, I heard that it's almost a certainty that, because I have these Johnny Carson, Carnac, I can predict, I need to put on that. I think it's old fashioned, but I can predict the future. And I see the China C5, T5 category reverting back to the same number as the I5, R5 category, which means if you've been planning to file as a Chinese national, you had better get that case in because you're going to experience retrogression. Again, don't sue me. I just heard that from a little birdie. Maybe it's true, maybe it's not. But as Joe pointed out, I actually forgot that it was in the Visa Bulletin. Thanks for reminding me. And yeah, well, that's not good news. So the bottom line is there's not a lot of activity. The only thing that's going to be around for most people is direct EB-5, but no pool direct. So, you know, it's one-offs. Not sure how all of that's going to work. Okay, so this is my little reserved visa category prediction chart. This is based on guesstimates. This is not factual information. But we've got some numbers here, and they're worth looking at. FY 2022 employment limit was 280,000. That's the double quota because normally it's 140. EB-5 limit is 19,880. 20% set aside, 3,976. Per country limit, remember every country only gets a fixed number. So every country, including China, gets 278 visas. Divide by 3.5. I think for China, you can actually go lower, but the families are getting bigger. I think you could divide by 3 maybe. Bottom line is going to be about 80, maybe 100 Chinese cases, plus any unused from the rest. So there should be spillover. So there may be a whole lot more, but the bottom line is there is one estimate, and this could be wrong, that there will be close to 3,900 left over starting in October. Add that to the projected limit for 2023, which is lower, 14,200. Look, obviously these numbers are very specific, so they've come from a reliable source, but they are projections. So we add that to the 2,840 for fiscal 2023, and we've got a hefty 6,740 rural set-asides. That's approximately 500 cases. Scratch that. Approximately 500 visas per country, 135 cases under rural projected for next year. This is optimistic. And China can, of course, get the others. But if you actually boil it down to this, even with this double quota, quadruple quota, the rural set-asides infrastructure is 3 per country. Yuck. You know, could that be oversubscribed? Yes. How exciting is that for a developer to chase 3 per country? But remember, China virtually had no quota and only got leftovers. So this is per country. It's a little bit pessimistic. But the bottom line is, I think it's important people understand how many the per country set aside and projection for this year plus unused for next year. We would probably be at, Suzanne's asking another brilliant question. Yes, that is correct. 7% per country limitation still applies. That aspect of the U.S. immigration and nationality, sorry, Suzanne's question popped up on my screen, which is, so the 7% per country limitation applies, and the answer is yes. That crosses over to all countries, Joe. You're looking perplexed.
Well, it's a spillover will be allowed, I think is her question, is will the leftovers be allowed?
Yeah, the leftovers will be allowed, which is why I'm saying, but each country only gets this many to start off with, and then they get leftover unused so they don't go to waste. But yeah, China was getting 70, 80% of the annual quota, when in fact their real quota was close to 0 for the last 15 years. So no problem with getting the leftovers, but the per country allocation, we might find, my point in putting this up is, we might find China India, Vietnam, maybe even one or two other countries potentially backlogged on the reserved set-aside categories. So Joe, here's an interesting question. If you apply for a rural set-aside visa and it's backlogged, could you potentially qualify for the other 60% as well? Or do you have to designate your reserved category? My point is the reserved category may not be so good moving forward. It's going to be good for a year or two, but after that, it gets backlogged. And then the question is, can you, I don't think we know the answer to that. So I'm just sort of throwing it out there. It's sort of a bit of a math puzzle to me. In the past, you could move from, I mean, in the old days, the regional center set aside was technically 3,000, but it didn't seem to mean anything. Now we have set asides that I think are meaningful because we have separate lanes. In the old days, we didn't have separate lanes for that 3,000. It wasn't broken down as specifically, if you get what I'm saying.
Yeah, that makes sense.
I'm getting very heavily into the weeds here. I really just wanted to do a little bit of math and calculation on what do these set-asides mean? How many visas are going to be issued in 2022? How many will be in 2023? Even with these massively inflated employment numbers. So for 2023, the estimated limit, and I don't think this is finalized, these are guesstimates, we won't get 140, which is 140,000, we get 200,000 visas, plus the unused from 2022. So look, it's going to be a healthy set aside, but it's not going to be as wonderful as we would like. I want to go back to this one. I've been talking about it all the way through because this is important for everybody's thinking. Concurrent and subsequent filing of adjustment of status. Remember, if you have a 526 pending and you are not backlogged, you are eligible to file an adjustment of status. I'm not getting into the issue of visa fraud and B2 entries, etc., and the 60-90-day rule. We did that last time. But the bottom line is if somebody is lawfully in the United States, even with up to 180 days of unlawful presence since last entry. So they could have had 2 years of unlawful presence. Well, if they had 2 years of unlawful presence, they probably triggered a bar. But assuming they don't have a bar, like if they were F1, and I spelt available wrong. Second typo. Anyway, 245K protection is there, can be used by a skillful lawyer. Oh, James, you're advancing the slide. That explains it. I'm going to get some new batteries. So a person who is lawfully admitted can file an adjustment. The good news is USCIS has posted the filing addresses for these 485s. So that's a recent update. When did they do that, Joe? It was like just a few days ago?
It was maybe last week or maybe 2 weeks ago.
Yeah. So you got to keep watching the website because they keep posting new stuff. So the addresses are there. We filed several of these. We're going to be filing more of them. And Joe, that also gives me the thought, with all these people filing 485s, are they going to end up chewing up all the quota and the people waiting for consular processing won't ever get any visas? I mean, just this whole system doesn't, it seems that the whole process is going to move towards adjustment. Those people waiting in Vietnam or China, the train may be very slow in coming, right?
Yeah, but they're not going to actually issue the visa until the 526 is approved. So with processing times, that could push it out a little bit.
Yeah.
So I agree. Yeah, they're going to see
a year or two. I'm looking 2 or 3 years down the road for those people waiting abroad. In the meantime, the people filed adjustment, chewed up all their visa quotas. Look, let's hope the State Department does this right.
Bernie, there's a good question here from right in the beginning of the panel.
Yeah.
What would you do for E2 clients who have adjustments? They would need a consular process for E2 extensions while the I-526 is pending?
Well, look, you always have to time this before you file an adjustment. The E2s are admitted for a period of up to 2 years. Number one is, I believe you can file an extension of stay on your E2.
If
And
you have a
that'll
pending adjustment,
even when you have a pending adjustment, the E2 is kind of a quasi dual intent visa. So, I mean, they may or may not approve it. It's like the same situation with a TN. Before you file an adjustment on a TN, you need to make sure that you have 2 or 3 years of valid status. So remember, the EAD is going to kick in hopefully after 6 to 8 months. So, you know, as long as you've got 8 months of status on your E2, you file your AOS, you're going to get your EAD hopefully within 6 to 8 months. You have your continued employment authorization. You even allowed up to 180 days of no employment authorization. Not that I want to encourage that. But at the end of the day, if somebody's on an E2, I'm ready to adjust them. Somebody's on a TN, I'm ready to adjust them. That's a little bit more complicated. Somebody's on a B2, well, they didn't have work authorization anyway. So if they're on the E2, and presumably a lot of the EB-5 direct filers are on E2s, so I'm not that worried, but you do want to, so my advice to the E2 person is you should travel immediately prior to filing your adjustment. You should travel like 2 months before you file your adjustment. So if you're planning to file an adjustment in July, you should be traveling now, re-enter, get a new 2-year admission, and then you are pretty much safe to have continued work authorization. You won't have continued travel authorization until you get your advance parole. So each case needs to be looked at separately. This is a good time to go through our questions. Joe, what else do we have? How to check the areas, high unemployment area? Joe, can you answer that one? How do you check high unemployment? The same as before.
yep, same as before. There's maps online. I really would advise people to pay an economist that small fee and make sure you get it professionally done, because it's going to be the basis for that 250K difference, and it's a worthwhile investment.
So we got a comment from Colin Baring. Firstly, Colin, thank you for all the good work you're doing and eating on the litigation and spending all your hard-earned money on fighting for the program. We do appreciate everything you've done. Joe, do you see the question? No, interest rates will not increase EB-5 capital. EB-5 proliferated because there was a market demand from investors who thought EB-5 actually delivers a green card, and they discovered the option not because there was an increase in demand for capital. We could debate that. I know you're at the center of it all, but we do want to share all views, and I want to use the opportunity to thank you, Colin, for your work on behalf of the program. You've certainly been at the front line fighting for immigrants and this program. So thank you very much for all of that. And no, I don't claim to be a expert in EB-5 capital. I expressed a view which may or may not be accurate. All right, so this gentleman here, I'm a permanent resident of Canada and an Indian citizen. While filing DS-260 would be getting an interview in India be quicker than in Canada, not necessarily, it's all the same. It's pretty much the same waiting line, and they actually want you to have your interview where you are resident. So I would designate Montreal. But as I mentioned earlier, sir, if you're eligible to adjust and you had like a dual intent visa or even a TN, I'm ready to do it off a TN provided we wait 90 days. So yeah, I think we answered all the questions. What about in the chat column? Any more questions, Joe? Good ones?
No, just see here. Did you say sample projects and econometric studies were not part of the I-9526? It seems like economists are very busy right now writing sample BPs and economic studies. So in the I-956, you have to demonstrate with reasonable predictions supported by economic, studies that the jobs are going to be created. So that's what they're working on. What I'm suggesting is that the offering documents, the limited partnership agreement, operating agreement, more like the securities types documents are not necessarily going to be included in this regional center application. That would come after the I-956 is approved when they're filing for project approval.
So it's going to be a relatively skimpy application is the bottom line, and fairly easy to adjudicate quite quickly. I want to do a shout out to my friend Stuart Ferguson from my hometown of Durban. Yep, I'm definitely going to be coming to visit. Look forward to it. I'm going to hold your feet to the fire on that one. Stuart, I assume there's a lot of interest again in the EB-5 program. Joe, I want to make sure all the questions are answered.
Can you talk a bit more about grandfathering and how it impacts I-526s filed in November 19 for regional center? So this is a very complicated issue. And when you look at the question and answers that USCIS posted last Friday, they pretty much indicate that someone who filed prior to July 1st, 2021 can still establish eligibility for their 526, even though the regional center associated with that petition is no longer designated. So you're grandfathered in that sense, and that they're going to continue to adjudicate those cases, even if the regional center is no longer technically in existence. And there was a great question.
What if you can't get documents, Joe? What if they can't get the documents?
Well, that's the issue. And it's making sure that you're working with a regional center and your new commercial enterprise, and they're working with the job creating entity to get all of those documents, and that there's some sort of contractual obligation and remedy if they breach that contractual obligation.
Yeah, but you got 90 days, Joe. You got 90 days to file that 829, and we've been in that panic situation where the regional center doesn't cooperate or doesn't have the documents, and you got 48 hours left, and everybody's sweating bullets to file because you have to file in one package. Joe, I have another simple question here. New EB-5 Reform Act does not permit pooled funds for direct EB-5. Does this mean only one foreigner can invest in the project, even if they're basically saying, does that mean LPRs or US citizens can't join in? I don't think there's any problem with LPRs or citizens investing in the project. It's just that they won't be able to file for immigration benefits, the LPR. Well, they're already LPRs. I mean, there's no prohibition on other people investing, right?
That's how I read it. And they will also make sure that any LPR or US citizen who invested in that new commercial enterprise, USCIS will likely ask, well, how did they get the money? Show me source of funds for that.
That's
for
the
that as
big
well.
one, Joe, is that, so what you're saying is that we now got to do source of funds on the other non-immigration investors as well?
There
was talk about that.
Yeah, I mean, we've seen that in recent requests for evidence on direct EB-5, where they,
That's absurd.
Where they cite the regulation and they say, you can use other capital that's non-EB-5 as long as it's lawfully obtained. And so they're saying, okay, well, show me that it's lawfully obtained.
Well, good luck doing source of funds on US citizens. They're not going to want to do that, but I think that's important. Okay, so I think we have covered all of our questions for today. This is another question from my friend Bernie Rojano in Texas, the business plan writer. How's the surf today in Malibu? I don't know. Got to go have a look. Hey, Bernie, how you doing? Come visit soon. So anyway, thanks, folks, for joining us today. I hope you've learned something. Some of what we're presenting is speculation because we don't know yet, but we want to share with you all the information we have. Hopefully you picked up a few tidbits today. This is all starting to make sense to me, at least. So we think that there are good opportunities. The EB-5 program is a viable option. Bottom line is, if you're not going to get family immigration, and you're not going to get employment sponsored, and you're not a genius for EB-1 self-sponsored, and you don't win the lottery, it's pretty much, or an asylee or refugee, this is pretty much the only way you're going to get in. So for many of the EB-5 clients that we see, there is no alternative choice. for many people who are on E2s. There's no ways you're going to get a green card. You can stay here for 50 years. You'll never get a green card. So you have to do EB-5 in many instances. So the program remains viable. There's our little pitch. We now have 9 offices. When I was talking about Joe as the smart partner, the real smart partner is Vivian Zhu. Sorry to make stupid jokes, but Vivian is just like a rock star in this area. When we get stuck, we go to her. She seems to know all the answers. She just had a baby, so she's staying a little bit low key. But thank you for joining us, everybody. I hope you learned something today. We'll do another one. I want to do one final plug. Ayla is doing, American Immigration Lawyers is doing an EB-5 conference. This is a comprehensive one. Every big name in the industry, all the top lawyers will be filling you in. So please join us. Joe is doing a panel. I'm doing a panel, but really all the rock star lawyers will be there. So this program starts this week, actually, and encourage you all to register. So thank you so much. We have one last question that I'm going to take from my friend Anthony Corder. Will USCIS continue to process 829s based on approved 5 that were filed in June, even if the regional center is not? The answer is yes, correct? So Anthony,
correct. And they continue to do that.
They're processing your 829s, doesn't matter. Hong Kong nationals who have 526 pending in RC, since concurrent is allowed, can they enter US with a B2 visa? Okay, no, if you enter on a B2 and file an AOS, as soon as you enter, you will be zapped with visa fraud and banned for 99 years. If you enter as a legitimate visitor with an intent to see Mickey Mouse and Snoopy, and after 90 days, you talk to Joe and he says you might be eligible to adjust, then you can adjust. But if you enter with non-immigrant intent and tell the officer you're coming to see Mickey Mouse and Disneyland and you file for a green card the next day, you are toast. But the good news is, coming from Hong Kong, is you have a separate mini quota of 3,000 annual quota, so you're not subject to the China quota. I tell every Chinese national, marry somebody from Hong Kong, because that'll take you out of the visa waiting line. I'll stop making silly jokes at some point, but that is the answer to your question. We are now over time, 4 minutes. Thank you, everybody, for joining us. Please register. Go to ayla.org and register for the EB-5 conference this week. It will be the best EB-5 conference you've ever seen. This is just a taste of what you're going to see. So all of you should register, and you're going to hear all the top lawyers opine on how this program is going to work. So on that cheery note, thank you, everybody, for joining us, and we will see you again soon.